Welcome to US Visa Updates. If you're a green card holder or planning to become one, what I'm about to share with you today could fundamentally change how you view your immigration status in America. Recent developments have sent shockwaves through immigrant communities nationwide, and understanding these changes isn't just important, it's absolutely critical for your future in the United States. Stay with me through this entire video because the information I'm sharing could make the difference between maintaining your legal status and facing consequences you never anticipated. The immigration landscape in America is experiencing one of its most dramatic transformations in recent memory, and lawful permanent residents. People who have worked incredibly hard to obtain their green cards are now finding themselves in a position they never expected to be in. For years, decades even, there was an understanding, a widely held belief that once you received your green card and became a lawful permanent resident, your status was secure unless you committed a very serious crime. That understanding, whether it was entirely accurate under the law or not, shaped how millions of people approached their lives in America. They bought homes, started businesses, raised families, and built entire lives on the foundation of that green card status. What we're witnessing now in early 2026 represents a fundamental shift in how immigration enforcement is being applied to green card holders. This isn't speculation or rumor. Multiple sources familiar with internal policy guidance at the Department of Homeland Security have confirmed that deportation priorities have been significantly expanded to include categories of lawful permanent residents who previously would have faced minimal risk of removal proceedings. We're talking about individuals who have held green cards for years, some for decades, people who have established deep roots in American communities, who pay taxes, who contribute to the economy, and who consider the United States their home. The magnitude of this change cannot be overstated. Immigration experts, attorneys who have practiced in this field for 20 or 30 years, are describing this as one of the most significant enforcement shifts since the early 2000s. What makes this particularly concerning is not just that the rules have changed, but how broadly these new enforcement priorities are being interpreted and applied. The coordination between United States citizenship and immigration services, immigration and customs enforcement, and customs and border protection has intensified to a degree that many in the immigration legal community find unprecedented. Let me be very clear about what's driving these changes. According to official statements from senior Department of Homeland Security officials, the administration's position is straightforward and frankly quite stark. They are emphasizing that lawful permanent resident status does not provide immunity from immigration law enforcement. The argument being made at the policy level is that the law has always contained provisions allowing for the deportation of green card holders under certain circumstances, but that enforcement of these provisions was inconsistent, sporadic, and failed to fully implement what the Immigration and Nationality Act actually allows for. What this translates to in practical terms is a more systematic, more methodical review of green card holders who may fall under the various deportability grounds listed in immigration law. To help you understand the scale of what we're discussing, internal audits that were conducted in late 2025 reportedly identified tens of thousands of cases where green card holders had unresolved legal issues that could potentially trigger removal proceedings. Tens of thousands. These aren't people who committed violent felonies or engaged in terrorism. These are individuals whose cases, when examined under the new enforcement framework, reveal issues that were previously overlooked, deprioritized, or handled through discretionary relief. For those of you who have gone through the green card process, whether through adjustment of status, consular processing, marriage-based petitions, employment-based petitions, or any other pathway, you know how complex and detailed that process is. You submitted countless documents, attended interviews, provided biometric information, underwent background checks, and finally received that precious green card. For many, that moment represented the culmination of years of effort, thousands of dollars in fees and legal costs, and the beginning of a new chapter as a lawful permanent resident. The operating assumption for most people was that once you cleared that initial hurdle, once you were approved and received your green card, the hard part was over. Barring something extremely serious, your status was secure. That assumption, which again was reinforced by how enforcement was actually conducted for many years, is now being fundamentally challenged. The new guidance that has been issued places a much stronger emphasis on mandatory referrals from USCIS to Immigration and Customs Enforcement when certain red flags appear during what should be routine interactions with the immigration system. Think about that for a moment. You're filing Form I-90 to renew your green card, a standard administrative process, or you're submitting Form N-400 to apply for naturalization, taking what should be the exciting step of becoming a United States citizen. Or perhaps you're filing Form I-130 to petition for your spouse or child to join you in America, exercising one of the fundamental benefits of having a green card. These are all normal, legitimate interactions with the immigration system. Yet, they can now trigger enforcement reviews that lead to removal proceedings. So, who exactly is being targeted under these expanded enforcement priorities? This is where the situation becomes even more concerning because the categories are broader than many people realize. First and foremost, green card holders with criminal convictions that were previously considered minor or non-deportable are now being reassessed. We're not just talking about aggravated felonies or crimes involving moral turpitude, although those are certainly included. We're talking about offenses that many people, including some immigration attorneys in the past, would have considered unlikely to result in deportation. This includes certain fraud-related offenses, even relatively minor ones. It includes domestic disputes that may have been classified as crimes involving moral turpitude, even if they didn't result in significant criminal penalties. Drug-related offenses that don't involve trafficking, but still appear on someone's criminal record, are being scrutinized much more carefully. The key point here is that convictions that might have been glossed over in the past or handled through some form of relief are now being viewed through a much stricter enforcement lens. The second major category involves green card holders who have spent extended periods outside the United States. Immigration law has always contained provisions about maintaining permanent residence and the risk of being deemed to have abandoned that status. However, enforcement of these provisions was often inconsistent. Some people would travel abroad for 6 months, 8 months, even longer, and return without significant issues. That's changing dramatically. Customs and Border Protection officers at ports of entry are now empowered, and according to reports directed to make determinations about whether a returning green card holder has abandoned their permanent resident status. These determinations can be made right there at the airport, and they can trigger immediate removal proceedings. Imagine returning from an extended trip to care for an aging parent or to handle a family emergency, only to be told at the airport that you're no longer considered a permanent resident. The third category that's facing increased scrutiny involves individuals who obtain their green cards through marriage-based petitions. This includes those who came through the CR1 or IR1 visa processes, as well as those who adjusted status within the United States using Form I-485 based on a marriage to a United States citizen or permanent resident. What immigration authorities are now looking at very carefully are past misrepresentations. And here's what makes this particularly troubling. We're talking about discrepancies that may have occurred years ago, that may have been completely unintentional, that may have seemed insignificant at the time, but can now trigger notices to appear in immigration court. Consider this scenario. During your green card application process, perhaps 5 or 6 years ago, you filled out numerous forms asking about your employment history, your residential history, previous visa applications, travel history, and countless other details. Maybe you forgot to mention a job you held for just a few months. Maybe you didn't recall a brief visa overstay from many years prior. Maybe you listed an address incorrectly or left out a previous address where you lived temporarily. In the past, these kinds of minor omissions or errors, especially if they weren't material to the actual eligibility determination, might have been overlooked or easily corrected. Under the current enforcement framework, officials can argue that your green card was obtained through misrepresentation, and that argument can form the basis for removal proceedings. This is why I cannot stress enough the importance of historical paperwork. Every document you submitted, every form you filled out, every statement you made during your immigration journey now matters more than it ever has before. Conditional green card holders and those who recently removed conditions using Form I-751 face additional concerns. The conditional residence period, those first 2 years of marriage-based green cards, has always been a time of increased scrutiny. But advocacy groups are now warning that any unresolved issues from the conditional period, things that might have been considered minor or were explained away at the time, may now resurface during other interactions with the immigration system. Even employment-based green card holders, those who came through the EB1, EB2 or EB3 categories, are not entirely immune from these increased enforcement measures. There are reports suggesting that individuals whose employment circumstances changed shortly after their green card was approved may face questions about the original intent of their petition. Did you really intend to work for that employer? Why did you leave so quickly after receiving your green card? Was there fraud involved in the original petition? Now, these questions don't automatically lead to deportation, but they can open the door to enforcement reviews that previously wouldn't have been initiated. The broader implications of these policy changes extend far beyond individual cases. Processing times across the board are expected to increase as USCIS officers are now required to conduct more thorough background checks and refer more cases to immigration and customs enforcement for review. If you're currently in the adjustment of status process, which already takes an average of 14 to 16 months, you should be prepared for potentially even longer delays as these expanded security reviews are implemented. Requests for evidence, those dreaded RF that ask for additional documentation, are becoming more detailed and more frequent. Applicants are being asked to submit court records, complete travel histories, and financial documentation going back many years, far beyond what was typically requested in the past. Legal analysts and immigration experts are placing this shift within a larger context of policy trends that emphasize enforcement over discretionary relief. While different presidential administrations have certainly modified enforcement priorities over the years, what we're seeing in 2026 appears to represent an effort to institutionalize a stricter, more rigid approach. The discretion that immigration officers once had to consider individual circumstances, family ties, length of residence, community contributions, all of those human factors that made the system somewhat flexible. That discretion is being significantly curtailed. Critics of these policies, and there are many, argue that this creates an atmosphere of fear among lawful permanent residents who have spent years, sometimes decades, building their lives in the United States. These are people who own homes, run businesses, have children who are United States citizens, pay taxes, contribute to their communities, and have every reason to believe they were secure in their status. Advocacy groups are warning that these enforcement policies will result in family separations with United States citizen children, potentially losing parents who are deported. Employers, particularly in industries that rely heavily on skilled immigrant workers, could lose valuable employees due to deportations that under previous enforcement priorities could have been avoided through various forms of relief. Now, if you're a lawful permanent resident watching this video, I understand that this information might feel overwhelming. You might be feeling anxious, worried, even scared about what this means for you and your family. That's a completely understandable reaction. But I want you to know that knowledge is your first and most powerful line of defense. Understanding these changes, knowing what triggers enforcement reviews, being aware of what's in your immigration history, these are all things that put you in a stronger position to protect yourself. From a practical standpoint, there are several things you should be doing right now. First, you need to be extremely cautious and meticulous when interacting with the immigration system. Every application you file, every form you submit needs to be accurate, complete, and thoroughly reviewed before submission. This is not the time to cut corners or rush through applications. Second, consulting with an experienced immigration attorney before taking any major steps like filing for naturalization, renewing your green card, or traveling internationally for an extended period is now more important than it has ever been. Immigration law is complex, and the consequences of mistakes or oversights can be severe. One thing that many people don't fully appreciate is that applying for United States citizenship through the naturalization process can actually trigger a comprehensive review of your entire immigration history. Everything you've ever submitted, every statement you've ever made, every interaction you've had with the immigration system can be examined during the naturalization process. If there are any inconsistencies, any unresolved issues, any problems lurking in your immigration file, they may come to light when you apply for citizenship. This doesn't mean you shouldn't pursue naturalization. Citizenship offers important protections and benefits, but it does mean you need to be thoroughly prepared and understand what's in your immigration history before you file that M400 application. Despite all the challenges and concerns these policy changes present, there may be some potential silver linings worth considering. Some legal experts believe that the increased clarity around enforcement priorities, even if those priorities are stricter, could actually encourage green card holders to address outstanding legal issues proactively. If you have an old criminal conviction on your record, this might be the time to explore whether it can be expuned or whether post-conviction relief is available. If there were errors or omissions in your past immigration filings, there may be legal channels through which those can be corrected before they become the basis for removal proceedings. Various waivers exist within immigration law that can potentially address certain grounds of inadmissibility or deportability, and being proactive about applying for those waivers when available could make a significant difference. The critical question that remains unanswered is how consistently these new enforcement priorities will actually be applied across the country and across different categories of cases. Will every USCIS office interpret these guidelines the same way? Will Immigration and Customs Enforcement focus their limited resources on certain categories of cases over others? And perhaps most importantly, will federal courts push back against what some legal scholars view as overly broad interpretations of deportability grounds? These are questions that will be answered over time as cases work their way through the immigration court system and potentially into federal courts. Looking toward the future, it's important to recognize that immigration policy in the United States is always subject to change. Congress could pass new legislation that modifies these enforcement priorities or provides additional protections for lawful permanent residents. The judiciary could issue rulings that constrain how broadly deportability grounds can be interpreted. There are already discussions in legal and advocacy circles about potential constitutional challenges, arguments that the new enforcement approach violates due process protections that should extend to lawful permanent residents. The political landscape could shift in ways that lead to adjustments in how aggressively these policies are implemented. Based on current political discourse, immigration will unquestionably remain a central and contentious issue throughout 2026 and beyond. Different political factions have dramatically different views about what immigration policy should look like, and those debates will continue to play out in Congress, in courtrooms, in state legislatures, and in public forums. As a green card holder or someone who is in the process of obtaining a green card, your best approach is to stay informed through reliable, trustworthy sources of information. This is why channels like US Visa updates exist to cut through the noise, to provide you with accurate information based on official announcements and reliable reporting, and to help you understand what these complex policy changes actually mean for your situation. You need to be monitoring official announcements from United States Citizenship and Immigration Services, paying attention to guidance issued by the Department of Homeland Security, and most importantly, being extremely cautious about misinformation that circulates online. There is so much fear, so much anxiety in immigrant communities right now. And unfortunately, there are people who will exploit that fear by spreading rumors, half-truths, or completely false information. It's crucial to understand that not every green card holder is at high risk under these new enforcement priorities. Your individual circumstances matter enormously. The pathway through which you obtained your green card, your criminal history or lack thereof, your travel patterns, the accuracy of your past applications, your ties to the United States. All of these factors play a role in assessing your actual level of risk. What's important is understanding whether you fall into one of the categories being more closely reviewed, and if you do, taking appropriate steps to address potential issues before they result in enforcement action. The path forward requires a combination of preparation, access to competent legal guidance, and ongoing vigilance as policies continue to evolve. The immigration landscape is not static. What's true today may not be true 6 months from now. Rules change, enforcement priorities shift. Court decisions create.